Thank you, Jackie. Thanks to all of y'all for being here. You are great Americans and patriots for your having this interest in this project. I'm involved, and we are all involved, in a nationwide movement designed to rein in our runaway federal government and to restore checks and balances that have been lost in our federal system. Now let me ask this question. How many of you are familiar with what's known as an Article 5 Convention of States? Raise your hands. Okay. So a little bit more than half of you are familiar with it. Let me give you a little bit of a history lesson about Article 5 to the Constitution of the United States. Back in 1787 at the Philadelphia Convention, when our founding fathers came together, there were many different interests they had balanced. There was the issue of North versus South in slavery. There was the issue of large states versus small states. And there was the issue of some states that wanted a strong federal government and some that were very protective of state rights. And so all of these interests they had to balance at the 1787 convention. And they came up with the federal government. But they didn't know if the federal government they were creating would be perhaps too strong or perhaps too weak. And they really couldn't agree on what it was because they didn't know. This was an experiment. And so they put a provision in the Constitution, in Article 5, for amending the Constitution. And the concept behind it was that if the government was too strong, it could be cut back. But more importantly, they thought if it was too weak, as existed under the Articles of Confederation, amendments could be proposed to refine it and make it better. And so there's a provision that we all know for amending the Constitution whereby 2/3 of each House of Congress can propose a specific amendment to the Constitution, and then that is referred out to the states, and if 3/4 of the states ratify that amendment, it becomes law. And 27 times that has happened in our Constitution and in our nation's history. But 2 days before that convention was going to approve and sign off on the final Constitution, there was a delegate, they called them commissioners back then, from Virginia by the name of George Mason, a name you've probably heard in history from time to time. And George Mason was absolutely convinced that this government that they had created was going to very quickly go beyond the powers delegated to it in this Constitution and seize more powers. He was convinced that it would very quickly intrude on the sovereignty of the states and that within a fairly short period of time it would be invading the freedoms and liberties of the citizens of the country. Does that sound familiar to any of you? He was convinced it would happen in his lifetime. And so 2 days before the convention was scheduled to ratify the Constitution, he objected and said there has to be a provision in the Constitution that allows that when this federal government becomes oppressive, it gives the states a mechanism to rein in the federal government independent of Congress. Because, as he argued correctly, Congress will never propose an amendment to the Constitution that reins in or cuts back on its federal power. And so there was another delegate by the name of Gouverneur Morris from Pennsylvania. And he, along with Elbridge Gerry, a delegate from Massachusetts, proposed to add a provision to Article 5 of the Constitution. And the provision that they added is the one whereby if 2/3 of the states submit applications to Congress asking Congress to call a convention of states, then Congress must call a convention of states. And delegates will get together from all 50 states and they can discuss and propose amendments to the Constitution that are consistent with whatever those within the scope of the call of those applications from those different states to Congress. And so that is what's known as the Article 5 convention process. Interesting thing about this Article 5 convention process It is not a mechanism for the states to bypass Congress when we have a runaway federal government. It is the mechanism that our founders put in the Constitution specifically for the purpose of allowing the states the opportunity to meet proposed amendments and try to rein in a runaway federal government. Now, the Convention of States project that Jackie mentioned and that I'm involved in and that we're going to be asking all of you to get involved in is a project whereby we are going to be organizing in all 50 states. The project was announced in August of this year, 2013. And already we're organized in almost or maybe slightly more than 40 states. And what we're doing is we're going to be lobbying the state legislatures to pass a resolution calling for an Article 5 convention. The purpose of which to be generally stated, is to rein in power of the federal government. The COS Project is a movement that's led by a gentleman by the name of Dr. Michael Ferris. Dr. Ferris is the founder of Patrick Henry College in Virginia and the chancellor of that college. That college is a conservative educational institution. Its goal is to produce conservative future leaders for this country. He is the founder of the Homeschool Legal Defense Association. He is a constitutional scholar, and he's one of the few attorneys that has ever actually litigated Article 5 in front of the United States Supreme Court. The COS Project is supported by Citizens for Self-Governance. That's a conservative think tank headed by Mark Meckler, and he is one of the founders of the Tea Party Patriots National. As I said, it was launched in August of 2013, and we've got state leadership teams set up in already somewhere close to 40 states. Now, I mentioned we're going to be lobbying the state legislatures to pass a resolution for a convention. Let me talk a little bit about what that resolution says. It's asking for an Article 5 convention to be called for three purposes. The first purpose is to impose fiscal restraint on the federal government. Now, to most people, that means a balanced budget amendment. More than 70% in the polling today of the people want a balanced budget amendment. And there's actually a group out there called the Balanced Budget Amendment Task Force, which has already gotten resolutions for Article 5 convention passed in a number of states, depending on your count, somewhere between 18 and 20, to call a convention solely to propose a balanced budget amendment. The Convention of States Project resolution goes a little bit beyond that because of the concern that if we pass a balanced budget amendment and only that, what's going to happen? Well, to balance the budget, Congress will have to do one of two things. They will either have to attack and do something with entitlements, and we all know they're not going to do that, or they're going to have to increase taxes. And so what would effectively be a good amendment could have a very unfortunate and unhappy result, and that would be a large tax increase. So the Convention of States Project goes further when it says impose fiscal restraint on Congress. It would allow this convention to go further and to perhaps propose amendments that would include tax reform in it, limitations on Congress's ability to raise taxes, possible limitations on the rate of taxation. And there's been a host of other proposals made that I won't go into today about how we can require Congress to essentially do its duty of passing a balanced budget. 49 of the 50 states already have to have balanced budgets, and as we all know, it's time for Congress to do the same. The second item that is promoted under the COS term limit is another item that more than 50%, the last poll I saw was over 60% of the country supports, and that's term limits, and specifically term limits on federal officials. That would include Congress. But it could also include future Supreme Court appointees and federal court judges in general in the future. So that is the kind of thing, you may have feelings one way or the other about that, but it is the kind of thing that the 50 states could come together and talk about and decide, is term limits a good thing? And if it is, what's the best way to do it? There's no automatic proposal out there for it. And then the third item covered under the Convention of States resolution is one that we generally refer to as to restrain and limit the power and jurisdiction of the federal government. On its face, that may seem somewhat broad, but what it really is just a restatement and reaffirmation of 10th Amendment principles, that the powers that Congress have are the limited powers delegated to it under the Constitution. But what are some of the things that that particular aspect of the resolution could promote that we know to be fairly popular and would likely get a kind of supermajority of support that we would want in order to get 38 states to ratify it? Well, one thing is the equal application of laws to Congress as they make them apply to us. That seems to be universally supported. How about an end for folks like yourself that have to deal with county governments? How about an end to unfunded mandates? Or requirement, like all the state legislatures, or most of them have, for single-issue legislation. What does that mean? It means that you don't have legislation that has a bunch of earmarks tied into it, and the kind of earmarks that we have going on now. Another possibility, you've heard a lot of people support the repeal of the 17th Amendment, which is the popular election of senators. I personally don't support the repeal of the 17th Amendment. But what I would like to see happen is possibly discussion over amendment whereby the states themselves could decide how their senators are chosen. It doesn't have to be uniform. Those two senators were intended under the Constitution to be there to represent the state legislatures. So if some states want to have popular election, that's fine. There may be state legislatures, however, who want to go back to the original process, which is appointment by those. So let's give them the option. As Jackie indicated, many of these proposals come within the scope of and are germane to the same Liberty Amendment proposal set forth in Mark Levin's recent book, The Liberty Amendments. The COS Project, you're going to be hearing more and more and more about it as it is gaining more and more momentum. It is something that many of the conservative commentators in this country have caught on to and support. But it also does have support from the left as well, and I can name some of those folks if you want it. But the project has been endorsed so far by Mark Levin, Rush Limbaugh, Glenn Beck, Mike Huckabee, Senator Ron Johnson of Wisconsin, and Senator Tom Coburn of Oklahoma. So today we're asking you to join with us in working together to lobby, in this case, our legislature at the state of Georgia, to help us lobby them to pass the CO resolution in the upcoming legislative session in 2015. And here's how you can do that. You can go to the Convention of States website, conventionofstates.com, and hit the tab that says Action Center. What action can you take? And we've got a tab that says Action Center. When you hit that, you'll have some options that come up. One of them is a tab for leadership. If you would like to be a leader, if you would like to become a district captain in this effort, there's a tab there that you can hit for leadership, for district captains. It gives you a job description of that. You can put in your name and your email and a little bit of information about yourself, and we'll be in touch with you to talk about that. There is a second tab that if that might be too much time and you can't take that you can look at. It's called the Volunteer tab. And we need volunteers of all kinds. We need people to send emails, to send letters, to make phone calls, to show up at the Capitol, to go to campaign events from time to time to support the people who support, the legislators who support the COS project. So, that is what we're here today to ask you to do. And with that presentation, let me open the floor to any questions you may have about Article 5 and the Convention of States project. Any questions? Mike? Yes.
Yeah, David. Since the beginning of the discussion of the Convention of States, one of the things that has come up most often is a fear of a runaway convention leading to opposition to it, whereby, let's call it a group of liberal states would get together and create amendments that went beyond the scope of what A, the convention was called for, B, what we the people want. So what's in there to prevent this runaway convention, or can it be prevented?
Well, thank you, Mike, for that question. That is an excellent question, and in fact, it is the question that we most often get from state legislators. It's the biggest concern that they express. Let's put that to rest. And I'm going to say this as clearly as you can say it. There is 0% chance of a runaway convention. And I'm going to tell you why. And I challenge anyone to out-debate me on this. First of all, as a practical matter, the states control this entire article convention process. They're the ones who make the call, make the application to Congress, and set forth in that call what the scope of the convention is going to be about. If you look at history and precedent, the states are the ones who appoint the delegates to this convention. Okay? If they're the one, if the state legislatures have made the call and say we want it to be for this purpose, then it is reasonable to conclude that they are going to appoint delegates who are going to follow that call. But the legislatures can go further. They can require those delegates to take oaths. And they can even, perhaps, go a step further and have penalties for those delegates to violate those oaths, if they violate it. And then, if the delegates go off to the convention and they get off task and they try to go beyond the scope of the convention, the state legislatures have the power and the authority to recall those delegates and to replace them with people who will stay on task. Now, even with all of that, that doesn't mean that there won't be some states who will have some rogue delegates get at the convention. But at these conventions, the voting is one state gets one vote, 50 states. So the likelihood that enough states would allow their delegates to go rogue so as to overtake this convention or hijack it is simply very low. I would submit impossible. But that's only the first hurdle. The second hurdle is this convention, what it does is it proposes amendments. It doesn't ratify them, it just proposes amendments. And then those amendments under Article 5 have to be referred to Congress, and Congress has to assign under Article 5 to those amendments a mechanism for ratification, which is one of two things. Either the state legislatures vote to ratify them, or Congress can require state conventions to vote to ratify them. That's how the 21st Amendment was adopted and ratified. So, it is the general opinion of constitutional scholars today that if a rogue amendment were presented to Congress to refer back to the states, that Congress would be within its power not to refer it back out to the states, not to assign a mechanism for ratification to it. So that would be the second possible hurdle. The third hurdle would be what immediately followed that, which would be a lawsuit. Okay? And once again, this would have to be presented to the courts, and the issue presented to the courts would be, would a convention call for a specific purpose under Article 5 that proposes amendments outside the scope? Are those amendments constitutional, legal, and are they required to be submitted to the states? And again, constitutional scholars generally agree that a court would find that those amendments did not have to be referred back to the states, and that in fact they were illegal. So that's the third. But then the fourth mechanism that precludes absolutely any possibility of a runaway convention is the actual ratification process that exists in the Constitution. And that is that even if there are rogue delegations that propose rogue amendments that get past Congress, that get past the courts, that get referred to the states, it takes 38 states to ratify those amendments. Now, let's say it's some crazy rogue amendment that is proposed by the left wing of our country. Let's say it's an amendment to repeal the Second Amendment. Okay, to get passed, the current breakdown of state legislatures is this. There's 28 state legislatures that are Republican-controlled, both houses. One of those is Nebraska is a nonpartisan state, but its membership is largely conservative and Republican, and there's only one house there. There's 28 states that are largely Republican-controlled. There are 20 states where both houses are Democratic-controlled, or some coalition that would be more left-leaning. And then there's 2 states, Kentucky and Virginia, that are split. Virginia is one house is Republican and one house is currently equal, the Senate, and then Kentucky is split each way. Now, for a repeal of the Second Amendment to be adopted, all 20 liberal states would have to adopt it. Both of the split states, which means 2 Republican-controlled houses in those states, would have to adopt it. And then 16 Republican states, Republican-controlled states, that's 32 houses, would have to approve it. So you've got 34 Republican-controlled houses in this country. And even if that changes by 5 or even 10 houses, you know, with swings in voting and left versus right, even if that changed, there's no way that can happen. And if you go the flip side of that, where there was, let's say there was a very conservative amendment, such as outlawing abortion at any time, anywhere, any place in the country. Well, for that to be passed, in addition to all 28 Republican states passing it, which I personally don't think would happen, but assuming they did, once again, you have the 2 split states, and then it would take 8 Democratic states. So, the whole process, the way it's lined up, is because of the breakdown of, and a relatively equal breakdown of parties within the country, it would require this convention to promote the kinds of amendments that would be bipartisan and nonpartisan. There's simply no opportunity. Then the final thing is, historically, if we look at it, we look at the conventions that met back at the same time, there were many of them as the founders. If we look at the 200 intra-state conventions that have occurred, more than that, since this country was founded, there's simply no evidence to suggest that a runaway convention would in fact occur. Did I answer your question?
I think you have. Thank you.
Okay. Any other questions?
David, can Congress establish the rules of the convention and the process for selecting delegates?
Well, that's another great question, and it's one that a lot of state legislators have for us. Let me just say this. Legally and politically, we don't think it can happen, and we don't think it will happen. Let me explain what I mean. Article 5 really does not address that issue. It's very simple, and it doesn't get into how the rules of a convention are established. So if a court had to look at this issue, its starting point would be to look at what was the intent of the framers. And the starting point for that would be, what was the whole purpose behind the Article 5 convention process? And if you look at the writings of Madison and others who took notes of the convention, it's absolutely clear that the whole purpose of the Article 5 convention process was to give the states a way to bypass Congress and propose amendments that they knew Congress wouldn't propose. So, to say on the one hand that you've got a process to bypass Congress, and then on the other hand that Congress can impose itself into the process by setting rules, would seem inconsistent, and I think a court would recognize that. Secondly, they would also go back and look at the 1787 convention and the other conventions that were held shortly before that our founders attended. There were regional and limited scope conventions that occurred before the Philadelphia Convention. And they would look at that, and when they looked at it, they would see that in every single one of those conventions, the states called them, the states set the scope of those conventions, the states decided what the process would be for delegations, and then when the delegates or commissioners arrived, they chose what their rules were. So a court looking at this would certainly be heavily persuaded towards that. And in fact, there's at least one case, legal precedent. It was decided, the case is Dyer v. Blair. It was decided in 1975. And the judge in that case was the future Supreme Court judge, Justice Stevens. And that case had to do with who had the authority to set the rules for a ratifying convention. Not the proposing, but a ratifying. They're both analogous. And Justice Stevens made it very clear in that case that the convention delegates themselves had that goal, or had that obligation, that duty, that authority, not the party, not Congress. So we've got that to go. Now, the naysayers will say this. They'll say, well, Congress has the duty to call the convention, and the necessary and proper clause of the Constitution says that when Congress has a duty to do something, it also has all powers necessary and proper to carry out that duty. So they would say Congress could, if it wanted, try to impose itself on the convention by setting the rules and delegates, etc. Well, an equally strong argument can be made that Congress's duty to call, everyone agrees that duty to call is what's called a ministerial duty. And therefore, the necessary and proper clause does not even extend to that, and if Congress tried to do it, it would be acting unconstitutional. That's kind of a legal mumbo-jumbo argument, but it's there. But also, if we look at, I don't think Congress will do something. And why do I say that? I don't think they'll try to impose themselves, for the following reasons. Back at the end of the 20th century, there were two movements that came very close to an Article 5 convention being called. There was a movement on apportionment in the 60s in response to the Supreme Court's claiming one person, one vote was the mechanism for states to apportion their legislatures. And then in the 70s and 80s, there was a movement for a balanced budget. And during that time, there were 40, according to one congressional report, there were 41 different pieces of legislation that were dropped in one of both houses of Congress, attempting to come up with some set of rules for an Article 5 convention. None of them even came close to getting passed. If we look at the current lay of the land, we have a divided Congress. They can't agree on anything. It's extremely difficult to believe that they could somehow find a way to agree on a set of rules for this convention. I don't think that would happen, particularly given the history that they've never been able to do it in the past. So, and then finally, the state legislators are already moving on this. On December 7, 2013, state legislators from all over the country met at what's now being called the Mount Vernon Assembly. 32 states were there. And those legislators started the process of drafting model rules for a future Article 5 convention. So the legislators, in many ways, had preempted Congress, and they've said, this is what we want. If a majority of the states make it clear to Congress that they don't want Congress getting involved in this, remember, they're telling their state congressional delegations that this is how they feel. Once again, the likelihood that Congress is going to get into this, given that they're already single digits popularity-wise, the likelihood that they're going to pick a fight with the states on this, I think, is very remote. So, for both legal reasons as well as political reasons, I think Congress has no role in this process and the states have total control. But it's a good question. Third question, Where was that third one? Right there? Okay.
We've been told that the original Constitution Convention was a runaway train wreck. Is this true?
Another super question. The question was, the history books say that the original 1787 convention was a runaway convention, and I could give you a 15-minute response to that, but I'm not. I'm going to give you the short. The short response is this. The Articles of Confederation Congress, the story goes, the Articles of Confederation Congress called that convention for the purpose of simply amending the articles, and that the delegates showed up and they went beyond that, and that makes them a runaway convention. That's not accurate history. The way that the Constitutional Convention of 1787 got called was a series of a few of the states that had gotten together for a regional convention in 1786, and not enough showed up for a quorum, thought we need to have a convention to do something about the Constitution. And so at that 1786 Annapolis Convention, they passed a resolution that said that there needed to be a 1787 convention for the purpose of, quote, to devise such further provisions as shall appear to them necessary to render the Constitution of the federal government adequate to the exigencies of the Union. Important thing there, when they used the term Constitution, as that term was used back in 1787, they weren't referring to the Articles of Confederation constitutional document. That term as used then, as it's used today in connection with the British Constitution, refers to the political system. So that call in 1786 wasn't to Congress, but to the states, saying we need to have a convention essentially for the purpose of doing whatever we need to do to get our political system working again, because the government was essentially falling apart under the Articles of Confederation. Well, that resolution went out to the states, and also went to Congress, and Congress didn't do anything about it. Instead, 7 states passed resolutions calling for the convention in Philadelphia, and all of them used that broad language of Annapolis that essentially would have allowed them to rewrite the Constitution, as many expected they would have to do. It wasn't until February 21st, just a few weeks before that convention was scheduled to convene, that Congress finally took that issue up, the Articles of Confederation. And when they took it up, here's what they did. First, New York, which was a state's right, they were opposed, they were against, wait a minute, I'm getting this wrong. New York, which was not in favor of proposing a new constitution, came in and they proposed a resolution to the Congress, which basically called for the convention, but limited that convention to purely submitting amendments to the Articles of Confederation. That resolution failed. Okay? So Massachusetts then submitted a substitute resolution. And it didn't call for the convention. It was simply a statement of Congress's opinion. It said, in the opinion of Congress, we think it would be expedient for the states to have a convention. Okay? They did say in that substitute resolution that it should be limited to amending the articles. But then they went a step further, and they said, and to report back to Congress a recommendation, let me get the right wording here. Let's see. To report back such alterations and provisions therein, and then they use the magic language, to render the federal Constitution adequate to the exigencies and the preservation of the Union. So the very provision that the Congress did eventually pass, which was merely an opinion statement, had that additional broad language in it, and therefore left it at least open to the delegates as to what their scope of the call was. When the convention convened in Philadelphia in 1787, 10 of the 12 states had authorized through the broad resolution their delegates to consider rewriting the Constitution. So it's just historically not accurate that it was a runaway convention. They came knowing full well that they might have to rewrite the Constitution. But when they were finished, they took that document that they proposed and passed, and they submitted it to Congress, not directly to the states, as sometimes is misstated. It went to Congress. If the Congress had thought that they had overstepped their bounds, all they had to do was reject it. But they did. They unanimously adopted the Constitution as it was proposed in, and then referred it out to the states to call conventions, if they so wanted, as the Constitution required, to ratify it. And then all 13 states called conventions. And then eventually all 13 states adopted it. Originally, North Carolina and Rhode Island rejected it, but then subsequently adopted it. So, the concept that that was a runaway convention just isn't accurate. And it's one of the things I'm glad that question was asked, so it gives me a chance to clear that up. Okay, any other questions? And let me say this before I turn it back over to Jackie. As I said before, the mechanism under Article 5 is not a mechanism to fix and rein in our federal government. It is the mechanism which our tremendously wise founding fathers gave to us. If James Madison walked in right now and he heard all the complaints that all of us have from time to time about our federal government, the question he would ask us is this: why haven't you called an Article 5 convention? So we have only ourselves to look to. The time has now come to do that. As to Georgia, let me say this. Georgia was the 4th state in this country to ratify the United States Constitution back in 1788, I believe. It needs to be the first state that adopts the resolution that saves that Constitution. So, thank you very much. I'll turn it back over to David.